While the USDA Risk Management Agency has issued new rules requiring insured farmers to initiate arbitration to resolve disputes with insured providers, attorney Grant Ballard says the final outcomes of such cases is unsettled. To his knowledge, no appellate court has ruled on the issue, and federal district courts have been split. Ballard discussed the arbitration clause during a National Agricultural Law Center webinar.
Now I'll move on to some of our litigation trends. Again, crop insurance dispute resolution, for any of those that aren't really familiar with it, it's a unique creature where the crop insurance policy contains an arbitration clause requiring most disputes between a crop insurance provider, often referred to as an AIP, and an insured farmer to be arbitrated. The qualifier to that is if there's a question of policy or procedure interpretation, that issue is to be submitted to RMA, Risk Management Agency, and then any ruling on the policy or procedure application or interpretation is then considered binding on the arbitrator. Oftentimes, we also see cases, crop insurance cases, where USDA RMA steps in and adjusts the loss or makes a claim determination. Those claims go to the USDA National Appeals Division. So you've got two different primary tracks. There are cases where some tort claims may survive arbitration and be brought in state courts. And of course, if there's a crop insurance agent error or omission, those claims may be taken to circuit court. So arbitration is required, but the state of the law, as the courts have addressed it across the country, is unclear on a few issues. First off, who has the burden to initiate arbitration? There were district court opinions going both ways. I would say no appellate court in this country that I'm aware of has ever addressed this question. In November of 2020, the policy was amended by RMA to reflect that the insured has the burden. I think that RMA tried to solve that issue, but I don't think it's been resolved, in my opinion. I'm not sure that it is equitable or a court will, I'm not sure an appellate court will affirm a finding that the failure of an insured to initiate arbitration when the insured did not seek a judgment or any relief. I don't think the appellate court in that situation will hold that a farmer has waived its rights to contest an alleged debt to an AIP. So I think there's some issues to be resolved, especially in cases where it is the crop insurance company that seeks relief or damages as opposed to the farmer. I think it's clear now, this law is clear. If a farmer's claim is denied and that farmer seeks relief in the form of a money judgment, the claims have to go to arbitration and the farmer has to initiate the arbitration process. There's no doubt about that. I think that it's much more murky when an insured says, "You owe me money, Mr. Farmer, Mrs. Farmer," and they say, "No, we don't." I think there's some unique issues there that will make their way into the courts in the future. Another issue that is completely unclear based on the appellate court decisions now is what issues does an arbitrator have the authority to resolve in a crop insurance arbitration? I think the policy has really tried to limit the scope of authority of the arbitrator, especially with the final agency determination or the interpretation of procedures provisions, wherein parties in arbitration are supposed to submit requests and final agency determinations on those issues to RMA. I think that, long story short, the policy says the arbitrator cannot resolve those issues, but the appellate courts want to give deference to arbitrators, and the appellate courts that have addressed the issues, specifically the 8th and the 11th, have effectively said that an arbitrator has the authority to decide what issues are properly in front of the arbitrator, and we're not going to step in and involve ourselves in that process. So there is some case law that suggests that now, 8th and the 11th Circuit. Now the Fourth Circuit basically upheld the FAD requirement and limited the role of the arbitrator. But I think that you can make a strong argument there's a clear circuit split now.